Thank you all for being here today and for taking time out for lunch to learn about this important subject. Let me frame the scope of our discussion today. We are talking about the legality under international law of the Jewish presence in the West Bank and the Jewish civilian communities known as settlements in the West Bank and Golan Heights. The mainstream view amongst international lawyers, reflected in the press, is quite easily described. It's that Israel has no right to be in these areas in any way, and that all Jewish civilian presence in these communities is a war crime. And this view is repeated without much analysis incessantly in the media. Any mention of Israeli settlements in the West Bank will be accompanied in the news with the qualification, which are illegal under international law. Israeli settlements which are illegal under international law. Notably, none of these references suggest that there could be some settlements that are legal, other settlements that are illegal, that it might be a fact-specific inquiry. Rather, the generally accepted view is that there is a blanket prohibition on Jewish civilian presence in parts of in the West Bank. And that's the view which I'm going to discuss today. And I'd like to start by pointing out that when the illegality of the settlements is noted, it's very rarely mentioned which provisions of international law they're illegal under. And that's what we're going to look at today. We're going to look at binding sources of international law and actually look at the text, look at how they've been applied in the past, look at how they've been applied to other cases, and see what international law, as I think fairly and objectively construed, says about the situation. Now, let me say a few words about why I need to speak for 50 minutes. Because I could do a 1-minute version of this, in which I would rattle off a train of United Nations resolutions, Security Council resolutions, General Assembly resolutions, in particular General Assembly resolutions, Human Rights Commission resolutions, a very impressive sounding list of resolutions, which all quite squarely conclude, in accordance with the mainstream view I just mentioned, that Israel's presence in these territories and the civilian presence there of Jews is entirely illegal. And this might be impressive because, after all, the General Assembly is international, and they're making legal claims, so isn't that international law? But that's not how international law gets made, and for those of you who, most of you I take it, work in the real world, so let me just say a thing or two about where international law comes from. Treaties and custom. These days, mostly treaties. But nations have to agree to be bound. The General Assembly is not a legislature for the world, and it does not have the power to make legal decisions. It's not like Congress. Now, why is it not like Congress? Not because we don't like what it says, but because the Charter of the General Assembly does not give it lawmaking power. For nations to be bound by rules made by an international body, they have to first delegate to that body the authority to make those rules. The General Assembly does not have that authority. Rather, it is purely a deliberative body. It's a schmooze fest. It's where politicians go to schmooze. The Security Council does have certain powers, but the General Assembly, they can express their views, but they are not legally binding. So that's why we need to speak a bit longer. Now, if they were legally binding, the question would actually be quite simple. Because since the General Assembly has actually decided that Zionism is racism, that would presume that the Jewish state would be illegitimate regardless of the boundaries, and that the quibbles about the boundaries are really not central. Now, many people in this context also cite the International Court of Justice advisory opinion concerning defense, which similarly is not a source of binding legal authority. It sounds better. It's the International Court of Justice, which people often mistakenly refer to as the World Court. Again, the International Court of Justice, by its own charter, only has jurisdiction to make binding legal determinations to parties that submit to its jurisdiction. This was not such a case. It was a case of an advisory opinion, which, as its name suggests, is of only persuasive authority. And you could read the opinion and see yourself how much you're persuaded. The opinion is very long, which might suggest at first that it has lots of analysis, but that's just the style of the International Court of Justice, and because every other page is French. In fact, the analysis is quite short on this point, because who are they providing advice to? It's important to know who are they advising with their advisory opinion. They were advising the General Assembly, who we just mentioned. The General Assembly had submitted the following question, and it shows that the General Assembly knew, like all good litigators, that how you frame the question is as important as the answer. The question was, bearing in mind Israel's ongoing illegal occupation of Palestinian territory, with all its detrimental consequences, implications and consequences, what are the legal consequences arising from the construction of the wall? So not much analysis was needed to answer that question. Now, so we are looking for authoritative sources of international law, and that's going to be a little bit frustrating because there aren't so many. Now, this is not just because it's the Israeli-Palestinian conflict. In general, international law is vastly underdetermined compared to municipal law. There's not a federal register of tens of thousands of pages of regulations being constantly promulgated. It's thinner, and one has to look a bit more closely. So before we turn directly to the question of settlements, which is really a question about the Geneva Convention, it's worth saying a few words about the history of the territorial claims to Israel and the West Bank. And I'm not going to go into who was there first, but it's pretty cool because we can cover 400 years in about 40 seconds. Up until 1917, if you were to ask anyone in the world who was the sovereign of this territory, it was the Ottoman Empire. They were the sovereign of the entire area and the area around that area. The Ottoman Empire collapses in World War I, and the newly formed League of Nations, of which Turkey is a member, and the winning powers are a member, the newly formed League of Nations takes upon itself the duty. One of the duties of the League of Nations was to create an international supervision system for the former Ottoman territories until they could become independently functioning states, what we today would be called state building. Instead of just having countries take upon themselves state building, which could have potential abuses, this would be supervised by the League of Nations. How did the League of Nations get this power? It's not just something they assumed. This was actually in the charter of the League of Nations. It was one of the specific tasks with which the League of Nations was charged. And the system for implementing this was called the mandate system. The mandate system. Today, most of us will only have heard, unless we take a particular interest in this, of the Mandate for Palestine, otherwise known as the British Mandate, quite inaccurately. In fact, there was a system of mandates, over a dozen, around the world. It was not just former Ottoman colonies, former German colonies. There was a system, a very complicated and integrated system of mandates, of which the Palestine Mandate was just one. And this is what the Palestine Mandate that was approved by the League of Nations, this was what it looked like. And I would just note that there were some other, it was part of an integrated system of mandates in the Middle East, with Syria, from which Lebanon was also formed, being a mandate for the French, and it doesn't fit on this map, but Iraq was a mandate for the British. So there were actually two British mandates, the mandate for Mesopotamia. If you examine the proceedings of the League of Nations, the 99.9% of this discussion was about the Syrian and Mesopotamian mandate, because that's where the oil was. The Palestinian mandate was considered rather uncontroversial. So this is what's supposed to happen with this Palestinian mandate. It's supposed to be a national home for the Jewish people. And what's that principally mean? That means for close settlement by the Jews. In other words, it suspends the Turkish ban on Jewish immigration. Ottomans had traditionally restricted Jewish immigration into Palestine. That is now suspended to create a Jewish national home in this territory. Now, there's another provision which says that the mandate could be suspended on its eastern portion if there's not enough Jews, basically, for the whole thing. And the British immediately exercise this, and they create this thing, which is now known as the Hashemite Kingdom of Jordan, exercising their power under Article 25 of the Mandate. So what are we left? Leaving the blue part as mandatory Palestine under these particular provisions. So as you can see here, we're in the 1920s, and the borders of mandatory Palestine are quite clear, and clearly there's no such thing as a West Bank or a Gaza Strip in them. No, so this is pretty good, right? This suggests that based on the League of Nations mandate, Israel's title to the West Bank is as strong as its title to Tel Aviv. So if you want to criticize Israel's claims to the West Bank, you have to attack the mandate. And indeed, people do attack the mandate. The legitimacy of the mandate. Right? You have to say that the mandate we have to throw out. There's a strong rule in international law, Jussi Putatidetis, that you go with pre-existing borders, even pre-existing colonial borders, which these aren't. So when the International Court of Justice is adjudicating Latin American territorial disputes between two independent Latin American countries, they're actually deciding this by maps that they dig off of sunken 15th century Spanish galleons. So even the colonial origin of borders is not disqualifying under the jus hypotheticus. And here are very recent, very clear borders, which are presumed to continue. So you have to really attack strongly the League of Nations mandate. And that's what people do. They say, mandate, schmandate. What authority does the mandate have today? There's no League of Nations around. They decided this at San Remo. Isn't that like a bottled water company? Why should anyone care about the borders of the League of Nations? And that's what you have to say, because so far we're doing pretty good. America does not have a League of Nations mandate to explain its territories. So a League of Nations mandate is pretty good. It's better than most countries have as the basis of their territory. So there's an argument of illegitimacy. And there are really two answers to that. There's two answers. One is legal and one is practical. First of all, let me cite to you two people who make this argument against the mandate. One is dead and one is living. So Saddam Hussein argued against the mandate because when he invaded Kuwait, he didn't invade it without a claim of right. Kuwait was at one point historically part of Iraq. It was not for reasons of British policy included by the League of Nations in the mandate for Mesopotamia. Saddam Hussein says, why should we be bound by the mandate borders? What's the League of Nations to us? No country in the world concurred with that view. Now, Lebanon was partitioned from Syria to create an Arab Christian country next to an Arab Muslim country, much like Jordan was partitioned from Palestine to create an Arab Muslim country next to a Jewish one. And if you look at the map on President Assad's wall today, there's no Lebanon, because this was a decision of the mandatory, later ratified by the League of Nations itself. But Assad says, why should I be governed by mandate boundaries, by decisions of the mandatory? What's the mandate to me? And indeed, under this pretext, Syria occupied Lebanon for several decades. No country in the world agrees with this view. So if you're actually arguing against mandatory boundaries, the impact goes far beyond this little issue with the West Bank. It actually calls into question, if the mandatory boundaries are invalid, it calls into question the borders of Turkey, Syria, Lebanon, Israel, Egypt, Saudi Arabia, Iran, everything. Every border in the Middle East is the product of the mandate. So you need a very kind of a form of special pleading calling into question the mandate for Palestine, but not the mandate system in general. That's a little bit awkward. But also the mandates are not an anachronistic thing just because the League of Nations is not around. Indeed, the United Nations directly inherited the existing mandates that were not terminated. The United Nations took over. They rebranded them as the Trusteeship Council, like they rebranded many things. They changed the Permanent International Court of Justice to the International Court of Justice and so forth. But they took over those. And indeed, the United States was itself a mandatory power, a trustee of several now independent countries well into the 1990s. And Article 80 sub 1 of the UN Charter specifically validates the legitimacy of mandates issued by the League of Nations. So this is not something that we have abrogated, that we've grown past. Mandates are very much recognized by present international law. So this is pretty good as a start for boundaries. Now, of course, Britain announces that it is not going to stick around until the completion of the mandate after World War II. It's tired and wants to go home. And it's clear that this will result in war, and the United Nations famously proposes the partition plan. What is the status of the General Assembly partition plan for Israel? So its status, obviously, is recommendatory. That is to say, they held hearings. They said, this is what we think is fair. We are the new United Nations. We have a lot of legitimacy. And under the basic principles of international law, if all the sovereign parties had agreed, it would be binding. Sovereigns can bind themselves. They can waive their rights. But clearly, the General Assembly does not have, and did not purport to have, the power to draw sovereign boundaries, abrogate mandates, and so forth. So this was many people mistakenly think that the General Assembly, with its partition plan, created Israel or authorized Israel. It's really far from the case. They actually offered Israel half the territory remaining under the mandate, and had all the relevant parties agreed, that actually would have been the borders today. But indeed, it's not. So finally, as a result of the War of Independence, this is the first time we see these boundaries emerge of the green line, the West Bank, what's now called occupied Palestinian territory. And you see that the term occupied Palestinian territory is really quite accurate, because it's territory of the League of Nations mandate for Palestine, which was occupied since 1949 by Jordan in the West Bank and Egypt in in the Gaza Strip. So this is the first time these borders appear on the map. And I want to stress a few things about these borders. As you can see, they do not coincide with any previous demographic, topographic, linguistic, political, administrative, or territorial boundaries. They are simply the furthest extent of combined Arab arms in their attempt to prevent the creation of a Jewish state in mandatory Palestine. Right? Egypt invades from one side, Jordan, Iraq, and some other countries invade from the other side, and they have a Molotov-Ribbentrop type goal of meeting somewhere in the middle and dividing the territory along a yet-to-be-agreed-on formula. Right? Their goal, prevent the creation of a Jewish state. This is how far they were successful. And so we see, 1949 to 1967, this territory is occupied by Jordan in the West Bank and Egypt in Gaza, two totally different countries. How many UN resolutions were there condemning the occupation of Palestine 1949 to 1967? So I think it's obvious that there was zero, but what I found maybe surprising, there wasn't even a proposed resolution that failed. It was really not an issue. Not an issue. So what can we see from this map? So Jordan is occupying these territories. These are often called the 1967 borders. The 1967 borders. That phrase is inaccurate in two ways. First of all, they were not created in 1967. They were created in 1949. They were obliterated in 1967. And they're not borders. They're armistice lines. We'll explain the difference in a minute. So where did we get this green line from, by the way? So an Israeli colonel sits down with a Jordanian colonel, and they draw two lines on a map representing where their armed forces were, so they would try not to shoot at each other during the armistice. And the Israeli colonel happened to have a green marker. Now, so if you believe in the green line, if you believe that the legal regime changes when you cross this invisible line, then it's important, if you think the green line is a genuine concept, then this is part of the concept. This was provision 1, I believe, of the armistice agreement. It is not to be construed in any sense as a political or territorial boundary. That is about as clear as you can say that this is not a border. Why? Because of the next part of the sentence. Both sides retain a right to try to conquer the rest of it. That's the only thing they could agree on. Israel says the rest of it's ours, we're going to try to get it back. And Jordan says, yes, we agree, the rest of it is ours, we're going to try to get it back. And other than that, they didn't agree on much. So imagine a little asterisk next to the green line. And under the asterisk is this sentence. Not to be construed as a territorial political boundary. So it's not 1967, and it's not a border. Other than that, it's a pretty accurate description, 1967 borders. Okay, now, let's go back here. So here's the important little point. What is the legal status of these territories, 1949 to 1967, when they are under the occupation of two different Arab countries? What is their legal status? So let me submit a couple possibilities. One possibility is that they are Israeli sovereign territory under the belligerent occupation of various Arab countries. Various Arab countries. Maybe. I don't want to sell that to you. Here's another possibility. Another possibility is it is not Israeli sovereign territory. It is disputed territory in which no one has yet perfected sovereignty, and Israel has a legal claim. That sounds a very technical distinction, but what's the difference? Under one view of sovereignty, you actually need to control the territory at some point for it to fall under your sovereignty. So even though Israel is the success, the argument for the first view, that it's Israeli sovereign territory, is Israel is the successor state to the League of Nations mandate. Don't mind that it has a different name. They just decided on the name Israel at the last minute, but they could have called it Palestine. So Israel is the successor to the mandatory Palestine, and this is within the borders of mandatory Palestine. It's all part of the same thing. The other argument is, well, Israel never actually succeeded in asserting its control in these areas, so Israel has a claim of title based on the mandate. Now, what's Jordan have? Jordan doesn't have a very good claim to title. No countries in the world really recognize Jordanian sovereignty in this area. So there's a dispute over territory between Israel and Jordan. Israel has the better title, but it has yet to perfect sovereignty. That's maybe a little gap, but I think it's important to stress why we don't know the answer to which one it is. Because international law is underdetermined. Right? You cannot open the Federal Register of International Law and find an answer to a question, what is the status of an international trust territory in which the trustee, the mandatory, abdicates before the completion of the terms of the trust, and different parts of the territory fall under hostile occupation of various countries contrary to the terms of the trust. There's no answer to that. And if I were to emphasize one point to today, if you don't believe anything the rest of what I'm saying, which you should because it's all true, whenever someone tells you, international law clearly says about the Israeli-Palestinian conflict, ask, from where do we learn that out? From what case do we learn that out? What's the precedent? Where does it clearly say that? What were the prior cases? Because usually the answer is just not so clear. Not so clear. So Israel has either sovereignty or a superior claim of title to these territories. Now let me note an important distinction here. When Israel takes back the West Bank and Gaza Strip and the Golan Heights and the Sinai in the Six-Day War, the legal status of the Golan Heights and Sinai is obviously going to be quite different from that of the West Bank. For the West Bank, Israel has a very strong argument. They say, look, this was part of mandatory Palestine, and it was just squatted on by the Jordanians for 19 years, but that shouldn't change anything. The argument for the Golan Heights is going to be a little bit trickier, because Golan Heights, if you were to, so a useful exercise, which I've conducted, is to look at books, to really figure out what's going on with the West Bank. It's not useful to look at books written since 1967, because then everyone knows how the story ends. Look at books written, international law books written before 1967, and see how did they describe this territory. So I have conducted this exercise. Generally, nobody says it's Jordanian territory. Nobody says it's Palestinian territory. And actually, nobody says it's Israeli territory either. It would be odd to say it's Israeli territory because Israel's not there. What do they say? They say it's disputed territory. It's one of these post-war messes, like the Kashmir and Korea. Those are the two analogies invariably used. Kashmir and Korea. Because remember, both Koreas claim the entire peninsula, so one of them is illegally occupying the other, but it's hard, you don't know which one. Those were the comparisons that were made. If you asked anyone in 1967, who's the Golan Heights belong to? They'd say Syria, of course. Who's the Sinai Peninsula? Egypt. This was uncontroversial. So Israel's claim to these territories must depend on some other principle, and that principle would have to be defensive conquest. Defensive conquest. This is weaker than the League of Nations mandate. Why? Because we know that the League of Nations mandate exists and has not been abrogated. We don't know whether defensive conquest exists. Now, if you ask most international lawyers, is there such a thing as, can you conquer territory by force? For sure, the answer is no. Why? Because aggression is made illegal under Article 2 of the UN Charter. You cannot use aggression against other states. So if you're not allowed to attack other countries, of course you can't keep what you gain in these attacks. It goes without saying. Right? If you can't steal, presumably you can't keep what you steal. But does the UN Charter rule out all uses of force? No. Self-defense is an inherent right. And the Six-Day War was universally at the time thought of as a defensive war. So if the ban on conquest is a corollary on the principle against aggression, if the war is not an aggressive one but a defensive one, then it seems the corollary wouldn't follow. Now, the consensus today of the international community, a consensus which only emerged after 1967, needless to say, is no, defensive conquests also are illegal. Now, again, this is the only defensive conquest we've actually seen under the UN Charter, the arguable defensive conquest. So there's not a lot of precedent here. But it's quite clear. Now, why is it clear? Well, because you can't tell the difference between aggression and self-defense. So we're worried that countries will commit aggression, call it self-defense, as a pretext for conquest. That's the argument. It's a policy argument. It's not a precedential argument. It's not written down anywhere. It's a pure policy argument. As a policy argument, it seems singularly weak. Because if you can't tell the difference between self-defense and conquest, we have a lot bigger problems here than the Golan Heights. Rather, the entire UN Charter is thrown into doubt. The UN Charter and its entire security mechanism presupposes that there's something called aggression, which is illegal and can be responded to with self-defense, and self-defense, which is legal, and you can invite others to help you, and you can appeal to the Security Council. If you can't tell the difference between self-defense and aggression, the implications go far beyond conquest. They go to the very structure of the UN Charter itself. However, I don't want to sell this too much either, right? Because while I would it's quite clear that there's no rule against defensive conquest, because there was no place for a rule to emerge. If a rule is at least connecting 2 points with a line, we've only had 1 point, and a particularly politicized one. But I can't say that defensive conquest is legal under international law for the same reason. There's only that. So what's the answer? There is no clear rule of international law. Now, there is a rule of international law, believe it or not, about what to do when there is no rule. So international law actually has a meta rule about situations in which there's no rule, which is one of the most fundamental rules of international law because it's very common that there's no rule. And that meta rule, known as the Lotus principle, says that unless there is a clear prohibitory rule, it's okay. And because there is such a rule in international law because international law frequently does not have rules to address particular situations. Needless to say, but I think it's fair to say that Israel's legal claim to the Golan Heights is weaker than its legal claim to the West Bank, which has going for it both defensive conquest and the League of Nations mandate. Now, it's interesting that you hear much more about the West Bank than about the Golan Heights, which suggests that maybe international law is not necessarily driving these claims. Okay, what can we see about Israel's presence in the West Bank? One point I want to stress. Whatever one thinks of the two-state solution, and let's assume, along with the Israeli government, that it's a great idea, to say that the 1949 armistice lines should be the presumptive legal basis for such a solution is simply to retroactively ratify the illegal pan-Arab aggression against Mandatory Palestine. Right? Arab nations invaded Mandatory Palestine to prevent the creation of a Jewish state in this territory. To say that as far as they got, that is where a Jewish state now can never be, is to retroactively legitimate what was at that time seen as clearly an unlawful aggression, and it's very hard to see why anyone would want to do that. Okay. That's the background about the territorial claims. Let's move on to settlements. So settlements and this is going to draw on some of the territorial background. First thing I want to stress is settlements is not a term of art in international law. There is no international treaty or instrument or rule about settlements. It is not an international law term. Where does the word settlements come from? As far as I can tell, the use of the word settlements is simply an adoption and translation of the Hebrew word for yeshuvim, which is a Hebrew word which literally actually means settlements, and applies to small startup communities on either side of the Green Line. It's just a Hebrew word for small town. So the word settlements is not an international law word. It's actually a word specifically about Jewish communities. International law does not use the word settlements. It uses a different word, and I think we'll see why they're characterized as settlements. Indeed, the only time, or the first time international law does use the word settlement is in the League of Nations mandate to recognize the Jewish right to settle, i.e. start small villages, irrespective of where on the Green Line, under the League of Nations mandate. So settlement under the League of Nations mandate is a good thing. Right? Jews are allowed to settle. But when people talk about settlement, they're talking about one thing. There's one particular sentence in international law which the entire argument against settlements hangs on. There's one prohibition. It's part of the Geneva Convention, Fourth Geneva Convention. And the Fourth Geneva Convention is a treaty made after World War II. All the countries of the world are pretty much members, about the treatment of civilians in wartime. A big section of Geneva Convention is about occupied territory. And and then there's a particular provision, Article 49. Article 49 is mostly, the vast majority of Article 49 is about what we would call ethnic cleansing. Sub-articles 1 through 5 of Article 49 are about kicking out the population of the occupied territory, kicking them out. That's what Article 49 is principally about. There is this one sentence, which, as the International Red Cross commentary acknowledges, was thrown in as a bit of an afterthought. 49.6. If it is the case that Jewish civilians are not allowed to live in the part of Mandatory Palestine occupied by Jordan from 1949 to 1967, it must be because of this sentence. This is the sentence everyone has in mind. Occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. Shall not deport or transfer its parts of its own civilian population into the territory that it occupies. Now, note it doesn't say settle, the word settle. The verb is transfer, not settle. I think that we can learn something from that. But before we even get to figuring out what 49.6 means, we need to ask ourselves, does the Geneva Convention apply? Does the Geneva Convention apply? One might think it does not, because under the terms of the Geneva Convention, it actually addresses when it applies. It says it applies to the occupation of the territory of a high contracting party, which is a fancy way of saying the territory of a member, signatory of a signatory state. Now, what was the relevant high contracting party whose territory this would be? Well, there are only really two possibilities. One is Jordan, and no one thought this was Jordanian territory. And the other is Israel, and it seems difficult to self-occupy. So, which high contracting party is it the territory of? Now, the international legal community says, no, 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 you're reading it all wrong. Really, the Geneva Convention is about helping people, and we want to help people more rather than less. So we're going to read it broadly in light of its policies. So what do you make of that argument? You know, it's like any argument about reading something broadly in light of its policies. It's rather an acknowledgement that you're not reading it narrowly in light of its text. So let's say the Geneva Convention applies. Let's say the Geneva Convention applies to territory that does not belong to any country. I think this would not have been an expected result before 1967. What does the provision actually say? The occupying power shall not deport or transfer. So first, let's look at the language. Right? We're going to look at the language of the provision. We're going to look at the history of the provision, the legislative history, the background, the problems it was responding to, and we're going to look at other cases in which it was applied. In other words, we're going to do the simple and natural process of figuring out what a rule means, like we do with any other statute. What's the text say? What were the policies motivating it? Let's look at precedents and how it's been applied in other cases. I think we would do this if we were interpreting any statutory or regulatory provision. Shockingly, this exercise has never actually been attempted for Article 49.6. So we are amongst the few to engage in this exercise. So what's 49.6 mean? So I would say transfer. What's the plain language meaning of transfer? The government shall not deport or transfer parts of its own civilian population into the territory it occupies. So first let me explain, how does the international community want to read this sentence? In the reading of this sentence by the international community, any movement of Jewish civilians into the West Bank would be illegal. Whether they go themselves, if they return to houses they owned before the Jordanians kick them out, if they buy houses from Arabs, if they move themselves, under any circumstances. So the international community wants to read this sentence as saying, the occupying power shall not deport or transfer parts of its own civilian population, and if they shall make it difficult for them to access the occupied territory, shall prevent them from going, and if they get there, shall make it difficult for them to stay, shall remove them. That might be a good rule, but it doesn't seem to be what it says. So does transfer apply to Jews simply building and buying houses in the West Bank? Now, the plain language of transfer would seem to suggest, first of all, who can violate 49.6? Yeah, let me start with this point. Who can violate 49.6? Only the government, the occupying power. This is not supposed to be a restrictive covenant imposed on private land transactions. It applies purely to state action. Purely to state action. It says nothing about, this is not an immigration provision, this is not a border control provision. The government cannot do this. Well, what is the thing that it cannot do? Transfer. What's transfer mean? Take people from place A and move them to place B. You take them from one place, you move them to another. Same with deport. You take them, you move them. Now, it seems that the international community, in interpreting this, has taken a page from Mitt Romney, ironically, and supports a view of self-deportation or self-transfer, but that's hard to see that that's what the provision could mean. Transfer, you take people, you move. Now let me give you an example. People say, but the government builds the roads. The government makes roads. Now it is the obligation of an occupying power to make roads and take care of all the normal aspects of life in the occupied territory, to administer this. But let me give you an example. If I drive from New York to Chicago, has the government transferred me to Chicago? It's built the roads, it's provided the police, right, so I don't get, bushwhacked on the way, provided security, very nice highway, originally created for security purposes, right? With so many analogies, the interstate highway system. It would be ridiculous to say that because the government has a highway, that it has transferred me. Right? What about the fact if I'm in New York and I buy a house in Chicago, and the government's giving me a home mortgage discount, a home mortgage tax credit. Has the government transferred me to Chicago? It would be a very unusual use of the word transfer. Very unusual. Now, 1/3 of the population of the West Bank, maybe, a third, a half, has been Jewish population, was born there. Were they transferred? They were delivered. Again, this takes extreme liberties with the word transfer. Now, let me demonstrate this textual point by reference to some parallel provisions. There's a very big argument about 49.6. Actually, yeah, so let me show you some parallel provisions. This is not the only place in which the Geneva Convention uses the word transfer. Right? So if I was a lawyer, which I'm not, and I wanted to know what a word meant in a treaty, I would look at how it's used elsewhere in the treaty. Remarkably, this exercise has never been undertaken by international lawyers. It's never been done. Take a look. Transfer in Article 5. Protected persons shall not be transferred to a power which is not a party to the convention. In no circumstance shall a protected person be transferred to a country where he or she may have reason to fear prosecution. Article 127. The transfer of internees, excuse the spelling, the transfer of internees. Protected persons shall not be transferred. In all these cases, it's clear it refers to concerted, coordinated, organized government action. The government's taking these internees and moving them, not the government allowing them to go somewhere. In no circumstance shall a protected person be transferred to a country where he or she may have reason to fear persecution. Are we to understand that to mean that a protected person is not allowed to go somewhere where they would fear persecution? Then they wouldn't be going there in the first place. So transfer refers to organized, if not forcible, then at least centralized government action of actually taking people and actually moving them from place A to place B. That's clearly how it is used every other time in the Geneva Conventions. And frankly, I said that the international consensus is against what I'm saying, but maybe on some level the international community agrees with me. Subsequent to the entire debate over what transfer under the Geneva Conventions mean, the International Criminal Court statute was adopted. And the International Criminal Court statute, it defines various crimes, genocide, and so forth. One of the crimes in the International Criminal Court statute is war crimes. Now, for war crimes, they don't just make up a new definition of war crimes. They rather incorporate, they simply cut and paste the definition of war crimes from the various Geneva Conventions. Right? You have a perfectly good Geneva Conventions, everyone agrees to them, so let's just cut and paste. And they cut and paste Geneva Conventions 3 and 4 into Article 8 of the International Criminal Court Charter. They make just one change in the entire corpus of war crimes, at the suggestion specifically of Arab countries, and this is why Israel did not sign the charter. They changed the provision corresponding to 49.6 to the transfer directly or indirectly. Ah, now we're getting somewhere. That's exactly what 49.6 doesn't say. Maybe, if it said that, it would be a little closer to the international community's reading. I still think it would be a little not so close, but maybe that's more like it. And that actually rather emphasizes specifically what's missing in 49.6. It's how they want to read 49.6. Now, Israel is not a party to the International Criminal Court, so it is not governed by those provisions. Okay, so that's the question of transfer, the meaning of the word as we see elsewhere in the Geneva Convention, in its natural meaning, and as it's used elsewhere in other international legal instruments. Now, why do we have this rule? What's this rule supposed to be about? Article 49.6 is about the follow-up to violations of Article 49.1. That is to say, as the drafting convention made clear, and as the International Red Cross commentary further notes, 49.6, the entire Article 49 was in response to German colonization practices in Ukraine and Poland. So what would they do? They'd kick Ukrainians and Poles out, and they would move Germans in. Nazi colonization of Poland. Now, the first question to ask is it possible, colonize is the term used by the International Red Cross commentary, can a people colonize an area which the League of Nations has reserved for settlement by them based on their historic connection to it? You colonize places to which you don't have a historic connection. I think that's almost the definition of colonialism. So can you colonize a place to which you have a historic connection? Okay. What was wrong with it? So what was the characteristic of these German settlements? That the transfers worsened the economic situation of the native population and endangered their separate existence as a race. This is the ICRC commentary. And that's a crucial point. That is to say, the point of these was to change the demographic composition of the target population. And that's why it was done in a company with it was done together with kicking them out. It's very hard to do this if you're not also kicking out the people at the time. The goal was to change the demographics of the area. Now, Israel has never had such a goal. All the settlers in the West Bank are at most 20% of the population. And indeed, if anything, the Palestinians have flourished as a separate race since 1967, having, for example, being recognized as a separate people for the first time. Now, here's the important point that arises in the Red Cross commentaries. Again, forgive the spelling error. So they say the following thing. The Red Cross points out that if you look at Article 49.6, it just says transfers. And if you look at Article 49.1, it says individual or mass forcible transfers. And what the Red Cross is saying, because it doesn't use the word forcible in Article 49.6, it does not refer to gunpoint transfers. Okay. What people want to make with this one particular observation by the International Red Cross is that it thus applies, they create a false dichotomy. They say, since it doesn't apply to gun to the head, since it's not just about gun to the head transfers, it applies to any transfers. It applies to any movement of individuals. Now, the opposite of gun to the head in the world of state action is not voluntary private movement. It's ordinary, not gun to the head state action. Like when a country engages in a project in which it organizes and coordinates an activity. That is to say, consider Article 45. Right? Article 45 did not have the word forcible in it. But clearly it refers to organized, coordinated, picking up and moving. And while these things don't have to be forcible, they still have to be actual transfers by the government. That is to say, the government has to be taking people and moving them around. Note another difference between 49.1 and 49.6, which the Red Cross chose not to comment on. Clause 1 of Article 49 says individual or mass forcible transfers. When it comes to kicking people out, you can't even kick out one person. But when it comes to moving people in, it says the occupying power shall not deport or transfer parts of its own civilian population. In other words, it does not speak about the movement of individuals of their own accord into the occupied territory. Now, why would you make such a distinction? Well, as a policy matter, why distinguish between? Why adopt? What would be the reason to distinguish between organized government-coordinated action and movement of people based on their own preferences and desires? The reason is really scale and effect. Actions by the government are going to be larger, quicker, and much more dramatic than various uncoordinated actions of private individuals. Now, let me say another word about the German example. It was clearly a response to German colonization. And one useful thing to know, if you're wondering, well, what did they have in mind? What was German colonization like? What was German colonization like? Again, this is not a question which international legal scholars have asked, much to my surprise. If you want to know what they had in mind, what does transfer mean, and you know the paradigmatic case were German transfers, what were these transfers like? So let me tell you what they were not like. Germany did not take out an ad, German individuals, there was no German Gush Eminim. There was no German private settlement movement that said, hey guys, let's go settle the, I guess not hilltops, but the fields of Poland. And the German government said, okay, we won't get in the way. Rather, the German government picked certain groups of Germans from various places, rounded them up into kind of central camps, gave them various tests to figure out who was the most German, picked amongst those, gave them classes in Polish agriculture and how to farm the lands that they were going to, trained them in particular for these purposes, and then, yes, put them on a train and took them to those places. They put them on a train and took them to those places. That's what the German transfer looked like. It wasn't some German guys buying some houses from some Polish guys. It wasn't some German guys moving into houses the Polish guys had run away from. The German government taking them, concentrating them, and then putting them in particular places. Let me give you a particular example which I think is very telling. Again, this has never been discussed in the international literature. You're hearing some cutting-edge stuff. Consider the difference between the commentary on the ICRC commentary and all the commentary on the Geneva Convention. So this was about the colonization of Poland, Ukraine, German colonization efforts. That's what it was a response to. Were those the only places that Germans moved to? No. After the German conquest of Europe, some Germans moved to Paris because it's a nice place. Some Germans moved to Prague because it's a nice place. Germans moved to all sorts of places under German occupation. Now, not as many of them moved. It was not as coordinated an effort. Nobody thinks that Article 49.6 was designed to stop that horrible thing that happened during World War II, that some Germans moved to Paris. No. So that's the question, if 49.6 was in place, were Germans moving to Paris, buying apartments, flats in Paris? Would that have been a violation? No one, after 1949, thought that that was what Article 49.6 was about. So the distinction, clearly, no one said that Article 49.6 was a response to Germans moving into occupied territory. No, it was a response to the German colonization program in Poland and Ukraine. That's a vastly important distinction, it seems. And people who talk about this generally know very little about the German colonization program of Poland and the Ukraine. So that's the history. And the history seems to map very poorly onto the use of 49.6 as a general prohibition on nationals of the occupying power entering the occupied territory. And then, finally, let me talk about how this has been applied elsewhere. That's probably the best thing, right? Let's say that we can't agree what it means. It's an ambiguous provision. Who knows? Who knows what the German thing was like? Unless you've taken a particular interest in this, you might think that Israel and the West Bank is the only occupation of anything, anywhere, and the only settlements anywhere. By the way, so just to clarify my previous point, I think the reason that the international community wants to refer to them as settlements is because it would be a bit awkward to say, we condemn the transfer of Jews to the West Bank, or we condemn apartment construction by Jewish transferees to transfer more of themselves into the West Bank, because it just doesn't sound right. Where's the transfer coming? So when the international community wants to condemn, some people want to build some new houses for themselves in Efrat, to say, we condemn the continued transfer. It just doesn't quite sound right. So I think that's why they use the word settlement. So thank God we don't need to figure out what the word transfer means based solely on the highly politicized context of Israel and the West Bank. Thank God there have been many other arguable cases of transfer of civilian populations into occupied territory. And we can learn from them. This is a research project, by the way, which it's an ongoing research project of mine. It's going to hopefully result in a long article or a book. I received some great assistance on this from the great Dana Bruska, an associate at Wachtell, who was a former student of mine. So it turns out there's a ton of these, and I've organized them in a particularly interesting way. So the first few are transfers into an occupied territory which previously had no sovereign. So that is a very close analog to our current situation. So Indonesia, when it conquered East Timor, there was no sovereign in East Timor. It was very similar. It had been a Dutch colony. The Dutch bug out. It's supposed to gain independence. It never does. Indonesia conquers it. Same with Morocco and West Sahara. West Sahara was supposed to become an independent country when Spain left, but the Moroccans conquer it before that could happen. Let me just tell you an interesting fact about the Indonesian settlement program in East Timor. It was massive, and it's exactly what a settlement program would look like. They took Balinese farmers. Balinese is the majority Indonesian ethnicity. And in Indonesia is a big multi-ethnic empire, basically. And they had a long-standing policy of moving their people around to islands with different ethnicities. And when they conquered East Timor, they continued to apply with this Balinization process. They would take Balinese farmers. They would take them to a camp. They would teach them how to farm in East Timor. They would give them some money, and then they would take them on a boat and actually move them to East Timor. What did the international community say? They gave them a World Bank grant for economic development. Morocco. The majority of the population of Western Sahara now is Moroccan settlers. Now, when you're talking about Morocco and Western Sahara, Morocco probably did transfer them, because you can't just really get from Morocco to West Sahara so simply by yourself. Perhaps the closest example, the closest analogy is Jordan and the West Bank. Well, what did people say about Jordan and the West Bank? Now, not many Jordanians moved to the West Bank because it was poorer than Jordan. Mostly the movement went the other way. But there were some projects. So, for example, the king of Jordan started building himself a palace in Jerusalem. Nobody said illegal settlement construction. You're the king of Jordan. How can you build settlement for yourself in Jerusalem? Nobody said illegal settlement construction. And that's a very close example. Now, recently, William Hague, the Foreign Secretary of Britain, he said something I thought quite remarkable. He spoke to why they care so much in Europe about Israeli settlements. I found it remarkable that he chose to speak to this because it seems to recognize that it's a question that begs an answer. And he said, well, because it's very close. It's a violation of the Geneva Convention. It's right next to Europe. We're Europe. They're right next door. So it can be a problem for us. Now, Turkey in 1975 invaded Cyprus and continues to occupy it to this day. The majority of the population of northern Cyprus are Turkish settlers. Now, Cyprus is not just geographically closer to Europe, it's in Europe. There was a resolution proposed in the European Parliament that did not pass, condemning Turkish settlement activity. That's as close as we got. Okay, now, what's interesting about all of these examples, or many of these examples, so let me give you the bottom line here. The bottom line is, in none of these cases did the General Assembly or Security Council suggest a violation of Article 49.6. In not one of these cases. More importantly, what we hear in the international community is, if 49.6 is violated, what's the remedy? The remedy is all the settlers have to be kicked out. That's actually how I started this project. I wondered, where do we get this idea that if it's illegal, ab initio, then the remedy is the removal of all those people? So in the case of Indonesia, Morocco, Turkey, and Vietnam, there were internationally sponsored, UN-backed peace proposals to resolve the underlying conflicts. Most of them didn't work out, like in Morocco and in Turkey and in Morocco and Turkey, but some did in Indonesia and Vietnam. In all of them, the question of the settlers was raised. They said the same thing the Palestinians said. So the Cambodians, at the end of the War of Vietnam, in the Paris negotiations in 1999, one of their demands was not just that the Vietnamese army leave, they say you have to take these Vietnamese with you. We hate them, we can't abide them. We'll never have peace if the Vietnamese, if the ethnic enemies stay. Enemies and Khmer just don't go well together. And the response of the international community said, you can't say things like that, that's racist. That's you can urge that the military leave, but you cannot demand that the people leave. In none of these cases were the settlers required to leave, and in most of the cases, the settlers were actually allowed to vote in a future plebiscite on the territory's future. Note that one of these occupying powers with settlements is Russia, notable for being a member of the Middle East Peace Quartet. Now, again, one thing to notice, these numbers of how many, so we have the number of settlers there and then the percent of the population in the territory that they constitute. You'll see that the ranges are huge. Right? Like in Lebanon, 300 to 400,000, and that's just the middle of the range. Estimates of Vietnamese settlers in Cambodia vary by hundreds of thousands. And really, the reason there's these gaps is we don't have a piece now in these countries documenting each and every individual who goes there. But what I would really like to stress, I think the example of France is very important. France was one of the winning powers of World War II. Were central in drafting the Geneva Conventions. And we're actually drafting the Geneva Conventions. Everyone knew that the winning powers were actually going to take some German territory and Italian territory, and they were very concerned that their actions not be illegal. And they asked some questions like, surely this doesn't mean like our occupation of Germany? No, that kind of stuff is okay. It doesn't apply to all occupations. That was the answer. And France exploited and controlled the Saar, a very wealthy area of Germany, well into the 50s. No one suggested there was any Geneva Convention issues. Okay, finally, what I would say is, I want to object basically. If you take nothing away from this, I think the word settlements is not useful. Because the word settlements assumes that all Jewish civilian presence in this area would have the same legal status by virtue of it being a Jewish civilian presence. If there are violations of international law here, it is because, maybe, perhaps, and I wouldn't argue in certain cases, certain actions of the Israeli government would be said to amount to transfer. This is strong. You could, for example, argue that when they take Russian immigrants and send them to places in the West Bank, maybe that was transfer. But it is impossible to speak of the legality of settlements overall. Right? The settlements are not a legal entity. The prohibition is on the movement of people. Some people could be transferred, other people could be not. It's actually a very fact-specific situation. But no one is actually interested in this. And the point I'll leave off, which I think illustrates how no one is really trying to look at Article 49.6 when they construe this. What's the worst kind of settlement? Worst kind of settlement is an illegal settlement. What's an illegal settlement? An illegal settlement is one which has been built without the permission of the Israeli government. Now, it's important to note almost all of the controversial settlements started as illegal settlements. Hebron, Shiloh, Ophrah, the most controversial settlements did not start by Israel saying to people, this would be a good place for you to settle. Rather, people went there, they settled, the army came and kicked them out. They came back, army kicked them out, they came back, army kicked them out. Finally, the army said, we're going to go do something else now. Now, how that would be a transfer is hard to understand. But there are still wildcat settlements, which have not been subsequently ratified by the Israeli government. And those are considered the worst settlements, the outposts. Right? Because people there are weird and they're pretty far right. So it would seem if there was any settlement that would be legal under international law, it would by definition be the ones that are illegal under Israeli law. So the illegal settlements, everyone should love the illegal settlements. When these kids go up in the hill and build a little camp, what's the Geneva Convention have to do with it? The illegal settlements should be the legal ones. Now nobody makes that claim. There's no international lawyer that says, yes, the settlements are illegal except for the illegal ones which are legal. Which again suggests that this is not about transfer, but rather about the Jewish presence in this area under any terms. Okay, thank you, and I eagerly await your questions.